My name is Nigel Winter. Here at Rawlison Butler, we know the amicable divorce is not a myth. Many people want an amicable divorce at the outset of splitting up. If this isn't achieved, it is invariably because they have adopted the wrong process. This is where collaborative law comes in. If a couple want to avoid going to court and want their family to remain intact after any divorce, after all, there may be mutual friends, future graduation ceremonies, weddings and christenings of grandchildren. They don't want these family events to be overshadowed by the memories of a bad divorce. Using the collaborative process, you and your lawyers agree not to go to court. In its place, you agree an agenda of items to discuss and do so round the table in a meeting with everyone involved. Everyone is on first-name terms and has the clearly defined intention of trying to reach an amicable settlement. The lawyers also have a vested interest in making the process succeed. People who come to collaborative law do so for a variety of reasons. Avoiding an expensive court battle and emerging with dignity are, in my experience, the most common reasons. In this process, both parties compile what are known as an anchor statement. These are the reasons why they have chosen collaborative law, and it's also very often a common statement of their shared values. At the first collaborative meeting, there are 2 rooms booked. This is so that the party can separate, take a breather, and if necessary read the anchor statement, helping them to recall briefly the reasons why they have taken the collaborative step and are trying to reach their own agreement rather than having one imposed upon them and their family by a judge in a court. One of the great benefits of collaborative law is that we hold meetings in these offices and we endeavour to help you reach a settlement as soon as possible. Unlike a court that closes around 5 p.m, we are at our client's disposal and these meetings are concluded when they request. We have so much more flexibility within the collaborative process, and we often cover issues within a single meeting that could take months to cover in the traditional process. In many ways, the collaborative process highlights the shortcomings of the adversarial approach. Both parties will have the benefit from hearing 2 lawyers discuss with them the pros and cons of their respective positions and come up with a common answer to the solution, rather than facing the prospect of months of expensive correspondence when the lawyers slavishly take up positions for one side or the other. I am convinced there will be a time when collaborative law will be the norm, and people look back on the court-based process as the real exception. For this reason, we run a free advice session for all people considering collaborative law as an approach, and I would be happy to discuss it with you further.